The United Kingdom has always prided itself on its unwritten constitution. The conventions and very British manners which govern the behaviour of our sovereign, Parliament and courts. But events since the 2016 EU referendum are testing the very limits of that constitution, as a government with no majority pursues a policy it cannot get through Parliament.
This touches on the question of the separation of powers between the three branches of government, the legislature, the executive and the courts. Now, generally the courts try to take a back seat in these sorts of cases because they recognise that they haven't been democratically elected, unlike Parliament, unlike the government. However, there should be no power which is unlimited, and that's essentially what this case is about.
And so the UK Supreme Court is being asked to rule on whether Boris Johnson's decision to suspend Parliament was motivated, as he said, by a desire to clear the decks and set out a new legislative agenda, or as his critics suggest, to prevent parliamentary scrutiny as a no-deal Brexit became more likely. Scottish judges ruled last week that the suspension was unlawful, but the High Court of England and Wales disagreed, saying the matter was a political decision and not for the courts, a point reiterated today by the government's lawyer, Lord Keane.
The court is not equipped to decide what is a legitimate political consideration and what is an illegitimate political consideration.
And vociferously rejected by Lord Pannick, acting on behalf of those who claim the suspension is illegal.
No Prime Minister has abused his powers in the manner which we allege in at least the last 50 years. That is back to the development of modern principles of judicial review.
The country's 11 most senior judges residing in the Supreme Court must now decide. This case may centre on the government's motivation when it chose to suspend Parliament earlier this month. But the very fact that the case is happening and the result when it's delivered raise much bigger questions about who's in charge and whether there are limits to the power of the executive.
What is at stake here is enormous. If the court rules against the Prime Minister in that it was illegal to prorogue, then that is absolutely huge. For the first time, the judiciary will be saying we have a role to play in any particular dispute that plays out between the executive and the legislature, and that really has never happened before.
Whichever way they decide will have serious implications. If they find against the Prime Minister, clearly it's very serious for his reputation and also for his relationship with the monarch. If they find in favour of the Prime Minister, this will play into the hands of the Scottish National Party and Gisela Stuart, who will say, look, there's the Supreme Court just not listening to what the Scottish courts have said.
The law is rubbing uncomfortably close to politics. There are perhaps two parallel struggles going on here. One inside court, which is vitally important to our parliamentary democracy and our constitution, and one outside, which is all about how this is being viewed in the court of public opinion.
For me, I don't think it's going to be terminal either way for Boris Johnson if the verdict goes for him or against him. If it goes for him, he gets to stand on the moral high ground for a bit, saying I was right all along, the law is on my side, and that boosts him a little bit. If it goes against him, then it's probably what's known in the trade as a considerable embuggeration. But this won't really change the price of fish in terms of the big argument, are we going to get a deal or not? Are we going to Brexit on October the 31st or not?
But the country voted, didn't they, to leave? Yeah.
The Supreme Court hearing is due to last for 3 days. The ruling, when it comes, will answer this legal dispute, but perhaps pose more questions about where authority will lie in the future.
That was Elizabeth Glinka. We're joined now by the Labour peer, Lord Falconer, who, as Lord Chancellor, oversaw the creation of the Supreme Court. James Meek, the author and journalist. Gisela Stuart, the former chair of Vote Leave and founding member of the Constitution Reform Group, and the former BBC chief political correspondent, John Sergeant. Welcome to you all. I wonder, Charlie Falconer, whether when you created this baby, the Supreme Court, you ever imagined it being used in this way?
Well, I did, not this particular case, but this is the focus now of what is legitimate constitutionally, and there is an identifiable body and an institution that will decide it. Our institutions are really under strain at the moment. People feel the politicians in Parliament has let them down, and this act by the Prime Minister in relation to prorogation on one view, looks an incredibly extreme, maybe unlawful act by the Prime Minister. Who do the public expect to resolve it? The courts. Do the courts have standing? They do in this respect.
Would you accept that there has been a creeping politicisation of the courts?
The courts have got involved more and more because the friction between the various parts of our institutions, particularly the executive and Parliament, has got stronger and stronger. And the courts are the only people who can resolve that friction. Has it reduced their legitimacy? I don't think it has. We still reach for a judge like Leveson when there is a really big issue.
Gisela Stuart, it was extraordinary hearing Lord Pannick talk about no PM has abused his powers in the way that Boris Johnson has for 50 years. Didn't that make you draw breath?
That would assume that I agree with the analysis. I think what we've seen is Parliament, in a way, being unable to find conclusions. And I think there's been a failure in that parliamentary process, and therefore it is turning to the courts in some way. Broadly speaking, I think the system has been by far more resilient than we would have assumed. But to turn to the courts to arrive at political decisions, if that is the outcome of this, that will have deep consequences for the way the judiciary is going to be appointed. Charlie, you shake your head. This is about the balance, the structure, the executive, parliament and the judiciary, and it is their relationship. And the minute I think you change the power of one of that jigsaw, that has consequences on the other parts.
But when you say it's failed to find a way, that isn't a reason to silence it, is it? I mean, that's what's happened. The foundation of our constitution is that Parliament holds the executive to account.
It does indeed, and the question was to what extent the length of this prorogation. I mean, I find it quite extraordinary that the MPs who have for the best part of 20 years left for several weeks to go to party conferences in July did not see coming that they would be away for much of September.
It goes absolutely to the heart of our parliamentary democracy. The executive can dispense with Parliament, save for two reasons. One, they need a finance bill and they need an army act to keep the army in place. That takes a week. So they only, if Boris gets away with this, they only need sit a week, a year, if it's purely political. And so you have to decide the limits legally of what the Prime Minister could do, and only the courts can do that.
Let's just revert to our lawyer roles here. It's a question of can he prorogue Parliament? Yes, he can. What we're questioning is the motives. I don't think there's any point us trying to preempt what the Supreme Court says.
No, I agree, but I think the importance of this has to be underlined.
I think both of us need to agree that if at this stage the courts look into his motives for having done so, into the mens rea of the act, then I think they're stepping onto territory they have before that not done so.
That is such a misunderstanding. Honestly, what the courts do the whole time is look and see how the motivation is in a minister. So the classic case is the minister who said, I'm not going to have a public inquiry, even though the statute allows me to, because it will embarrass me. Court said, your motive is terrible. We set aside that decision. If the motive here was shut Parliament up, that is a bad, illegal motive.
James, I want to just bring you in because Charlie Falconer seems quite excited by this stress testing at the Supreme Court.
Very excited.
Do you think that is shared? I mean, do people care about these institutions? Do most of the country care about whether these kind of institutions survive in the roles that they have?
Well, that's the thing. When I hear Lord Falconer use expressions like the people and we, I do find myself thinking, who is we and what people? I think that there is a division in British society, that it is not necessarily at all coincident with Leavers and Remainers, but it's more a division between people whose lives are very heavily invested in the world of the abstract. Lawyers, journalists, politicians, artists, everyone in the studio, and the other people who perhaps see things in more practical, more direct, more day-by-day, week-by-week ways. And those people may not see this whole delicate historical structure that has been built up so long and that is so interesting and so beautiful and must not be broken
And those are the people, for the most part, that Boris Johnson is talking straight to. He doesn't want it to be, upholding of institutions. He wants to be the person that says, bring it on, isn't he?
Well, he's hoping for a base like Trump's base. There'll be people who will say, oh, well, I break the law, I do this, I ran off with somebody, but I'm a regular guy, he's like me.
I ran off with somebody, what?
No, but this is what they make... I'm talking about the people who think like that. Now, there is a difference there, the difference between the typical Trump supporter and sophisticated Americans. But here the difference is we live in a much closer community and people are sort of sizing up Boris. They've got some pretty clear ideas. Lots of people don't trust him. Now, that's quite... He carries quite a weight into the court.
Actually, maybe more people do now. They like what he's saying.
No, they may like it, but when it comes to a simple question of trust, he's got form, and there he is in front of the judges. This is pretty a rich gruel, isn't it? And people are looking at this, and they're not thinking, oh, well, I'm not sure I agree with the Supreme Court. Should we have the judges involved? They're thinking, oh, he's up before the beaks. He's up before the judges now. He's in trouble. Will they get him?
So
there's a big element of that.
This man from right inside the establishment can make himself seem like an outsider when he takes on Parliament, he takes on the judiciary, he takes on anything that sounds sort of lofty and abstract, as James said, and he wins those fights. Or he loses those fights. He loses against Luxembourg, and it's still written up as somehow, two fingers up.
I mean, I feel you're right about that. It doesn't matter whether he's right or whether he's wrong. It doesn't matter whether he pushes it too far or breaks the law or breaks the Constitution or smashes up the institution. The only thing that matters is the point that James is making. It's the people who have no interest in the detail of the Constitution who will see him taking on the establishment. But all the lawyers and all the judges can do is apply what they conceive to be the constitutional standards. And that's what the 11 people in the Supreme Court are doing. And it's just not an answer for them to say, well, who gives a toss about that?
I just want to bring Gisela in, because you've been right at the heart of constitutional reform, of looking at this. Does it worry you if we are now in an age where, that argument can be put to one side, where you say, oh, well, the Supreme Court did what it could, but actually it doesn't actually have any effect on what happens next?
Yes, it does worry me. And I think the structures of the United Kingdom and the constitution arrangement, I think, have been becoming quite creaky well before the referendum. I think the way the four constituent parts of the United Kingdom relate to each other, all those things. And in the Constitution Reform Group, when we looked at a new constitutional settlement, the one thing we actually say, the institutions which work well, we leave untouched, in the judiciary.
Did you anticipate
works well? No, I don't think.
From the vote leave perspective, did you think that Brexit would have such a sort of tentacled effect on every institution now?
What I had not anticipated is that Parliament would spend 3 years being totally incapable of overcoming its own internal divisions. And that is what has brought the courts into this.
That's right. And then you've ended up in a situation where the Parliament has not acquitted itself well in relation to the dilemma. You can't then, however, end up with a Prime Minister who, in effect, dispenses with Parliament.
But the trouble is that in many ways Parliament has done well. It does reflect the deep divisions that have arisen in the country. It's quite difficult to turn around and say, oh, why can't they agree when the country can't agree? But I think here, and this is what I noticed today with the judges, they look pretty pleased. I thought they got the impression we now have a role to play in this, and our role is actually to be dignified, sensible, measured.
You don't
think
you're
right about that, but
that is going to make a big difference in terms of pure emotion. Lots of people see Boris as the one who's causing all the trouble.
I agree, but for them, though, this is not a role they would have wanted. Because
they're enjoying it, though.
Well, no, I'm not sure that's right. I think the courts are much stronger when politics does not force them onto the stage. They've not chosen this role, and it's a legal question, but it has political ramifications.
But if they run away from it, if they run away from this decision, how will our great Supreme Court look in the eyes of the public?
I think there's no running away.
This is the question, James. I just want to bring you in. This whole idea of where a country looks now for guidance, I mean, that sounds sort of slightly ridiculous, but that's where we are at now. We don't quite know which institution will survive or which will have the upper hand? I mean,
in the
even the
state
Queen,
of,
you know, this whole idea of whether the Queen had a choice in this or not.
in the state of division that we find ourselves in, that the institutions themselves, particularly the political parties, find themselves, there is this great division. But I think also it's not just a question of how the of whether the organisations are making the right decisions, whether the institutions are making the right decisions, but also how people perceive them. Are they actually perceiving them in the way that we imagine? Are they perceiving them as these historical institutions? Or are they coming to see them more like reality TV, more like sports, where you have your person that you support and the rules are simply enclosed and safe, and in some strange way there's no real danger of anything absolutely terrible happening.
Do you think it will impact what happens to Brexit next? Briefly, do you think this will change anything in the Brexit process?
Not necessarily about the Brexit process, but I think this will change significantly about the way we do politics in the years to come.
John?
I think the key thing is Boris, in the end, when the election comes, how well is he going to do? And all this stuff will then seem either, well, of course, we could see it coming and there's the downfall, or actually all this stuff rather played into Boris's hands. I think, and we don't know the result, but that's what we've got to look at.
I think it will change Boris, because if he is brought to line by the courts, and I think the courts have got to do something about him, he will then become much more careful about the way he handles Parliament and how he complies with the rules.
Thank you all very much. Thanks.